Thank you, Representative Howard. Now, Mr. LaCour.
Mr. Chairman, Ranking Member Grassley, and distinguished members of this committee, thank you for inviting me to testify about the U.S. Supreme Court's emergency proceedings. I'm honored to be here. My name is Edmund LaCour, and I'm the Solicitor General of Alabama. In that role, I litigate before federal and state courts on behalf of my home state. Many of our cases involve time-sensitive matters and requests for emergency relief made either by the state or by our opponents. And many of these cases have gone before the Supreme Court. I thus have firsthand experience with the High Court's non-merits docket, and in particular, its emergency proceedings. In my time before you this morning, I would like to make 3 points. First, the term shadow docket, though evocative, is ultimately inapt. As the committee is aware, this phrase was coined by law professor Will Bode, who used the term to refer to the thousands of non-merits decisions the Supreme Court makes each year. But current conversation about the so-called shadow docket has largely narrowed in scope to refer almost exclusively to the court's emergency proceedings. These proceedings hardly warrant such a nefarious name. Requests for preliminary injunctive relief are a critical piece of any court's business, including federal district courts, courts of appeals, and the U.S. Supreme Court. And far from lurking in the shadows, the Supreme Court's entire docket is freely searchable online. Now, while these emergency proceedings are often fast-paced, the reality is that litigation sometimes presents emergencies that require emergency action from whatever court is called upon to judge the matter. Second, the court's decisions in emergency proceedings, though often offering less guidance for non-parties than most merits opinions, typically serve the parties well. Two of Alabama's recent cases illustrate the point. The first case, People First of Alabama v. Merrill, required the state to seek emergency relief from the Supreme Court. Though the Supreme Court has long warned lower courts against changing voting laws on the eve of an election because such last-minute changes create risks of voter confusion, a federal district court nevertheless changed important Alabama voting laws weeks after absentee voting had already begun. The Supreme Court rightly stayed the lower court's injunction and allowed Alabama to again enforce its laws. The other case, Dunn v. Smith, did not go Alabama's way, but also illustrates the importance of the emergency docket. Willie Smith is a death row inmate who was scheduled for execution earlier this year. He asserted that the state's execution safety protocol violated his religious liberty rights because the protocol did not allow for his pastor to accompany him into the execution chamber. Alabama and the district court disagreed with Smith, but 24 hours before his scheduled execution, a divided 11th Circuit panel granted Smith an injunction. The state thus filed an emergency application with the Supreme Court seeking a stay. Both sides were able to brief our arguments and submit to the court the crucial information it needed to issue a thoughtful ruling given the emergency posture of the case. And while I think Alabama presented a strong case, a majority of the justices ultimately rejected it. Though the order was not accompanied by a lengthy majority opinion, the stay made clear that the state would either need to alter its execution protocol or delay Smith's execution while pressing on through the normal appellate process. And a thoughtful concurrence from Justice Kagan improved the state's understanding of the burdens it would likely need to satisfy going forward. Many of the court's emergency docket decisions fit this mold. Finally, the recent emergency docket decisions that have garnered attention from the committee are less remarkable than some have suggested. Most notably, the court's recent decision in the Texas SB 8 litigation to deny the plaintiff's request for an injunction was an entirely ordinary ruling. After all, one thing most everyone agrees on about SB 8 is that it raises unprecedented and difficult jurisdictional questions. It thus would have been extraordinary had the court granted an injunction against the defendants when it was highly doubtful the court even had authority to act. I'd like to thank you again for the opportunity to offer testimony today. I hope that what I offer is useful, and I'm happy to answer any questions members of the committee may have for me. Thank you.